All right, y'all. Chapter 4, marital property. Planned or unplanned, it makes a huge difference. All right. Don't find fault, find a remedy. Henry Ford. Case study 12, John and Marcia. John and Marcia led a comfortable life together. John was a doctor who specialized in delivering babies. Marcia was a nurse John had met at the hospital 20 years previous. She had stopped working long ago to concentrate on raising her and John's own children. Life was good until John was sued for malpractice. A child he delivered had a rare complication. John, his attorneys, and numerous medical experts, while agreeing the situation was tragic, maintained that the complication occurred in 1 out of every 5 million births. Nevertheless, the jury felt sorry for the mother and reasoned that John had $5 million to comfort her. John and Marcia were devastated. The judgment far exceeded John's malpractice insurance coverage, and now the plaintiff's attorney were seeking all of his and Marcia's assets, including their home. Plaintiff is the one that's fucking suing you. John thought that Marcia, as his partner, owned part of the property, which would not be subject to creditors' claims, but they had taken no steps to implement such a plan of protection. John thought that Marcia, as his marriage partner, owned part of the property, which would not be subject to creditors' claims, but they had taken no steps. They had taken no steps to implement such a plan of action or such a plan of protection. Key points: without active planning, asset protection of marital property will not occur. Because, she owns it too. She didn't do nothing wrong, In community property states, community creditors can reach the community property of both spouses. Community creditors can reach the community property of both spouses and the separate property of the spouse incurring the debt. In common law states, everything earned by the husband, savings accounts, annuity contracts, etc., and 1/2 of the husband's interest in jointly owned property, the house, is available to creditors. So they'll own that shit with your wife. Alright. It is important to note the distinction between the community property and the common law systems for ownership. Okay, it is important to note the distinction between the community property and common law systems for ownership of marital property. Community property laws are patterned after the civil laws of Spain and France and are applicable in Arizona, California, Idaho, Nevada, New Mexico, Texas, Washington, and Wisconsin. All other states adhere to the common law system derived from English law. In a community property state, unless John had taken prior steps to transfer ownership, all of his separate property, that which he brought to the marriage or inherited while married, and all of their community property, that which he earned during the marriage, would be subject to a creditor's claim. In a community property state, unless John had taken prior steps to transfer ownership, all his separate property, that which he brought to the marriage or inherited while married, and all of their community property, that which he earned during the marriage, will be subject to a creditor's claims. Without planning in the common law state, all of John's separate property, all of his earnings, and 1/2 of his jointly owned property, their house, is subject to the claims debtors. By a stroke of sheer judicial luck, an appeals court reviewed John's case and agreed that as a matter of law, his medical skills had nothing to do with the child's unfortunate complication. The judgment was overturned. John and Marcia were overjoyed and were immediately ready to engage in asset protection planning. John and Marcia agreed that because he was the one to be sued, it made sense to transfer at least half of their assets into Marcia's name. This strategy would work in both community property and common law states. John and Marcia discussed the downside to such a strategy, including the loss of control for John of various assets and an increased tax liability for some of the gifts to Marcia. But after the recent trauma, they felt the need for such protection. They met with an asset protection planner who, in order to determine the ownership and character of their property, utilized a combination of spousal gifts, marital property agreements, and family limited partnerships to achieve their goals. The lawyer made sure that all documents were signed and recorded so that no future creditor could later challenge the plan. For, as John knew, he had dodged a bullet this time, but the guns of sue-happy individuals were still threatening. For real, man. Conclusion. Asset protection for marital property requires active planning and implementation. There was no automatic exemption for marital property. In both common law and community property states, assets, in both common law and community property states, assets can be transferred to the less at-risk spouse for protection. While loss of control and gift tax liabilities are significant issues, the use of spousal gifts, because now the wife owns it, you gotta trust her ass. The use of spousal gifts, marital agreements, and trusts can offer significant marital property protection. You just gotta really trust her, man. She'll take off with your shit. It's crazy that like the big part of this book has to do with all that shit. You gotta fucking just protect yourself. Alright, that was the end of chapter 4.